Hey everybody!
Hey everybody!
It's Tony Pulicello live from Beaver, Las Vegas, back again for another episode of Ask a Beaver Anything with our fearless leader of this podcast, as well as the Beavers Behind Enemy Lines, the great, the glorious, the barrister that is Ellen Thayer. How are you,
Tony
Ellen?
Vegas? Good to see you.
Good to see you too, sir.
Do people call you Tony Vegas?
No, they call me Tony Soprano, but they never call me late for dinner.
Oh, okay. Speaking of dinner, but never mind. So what do you want?
Oh, inside joke.
You mentioned Beavers Behind Enemy Lines. Thanks for
tell us what's the latest and greatest on Beavers Behind Enemy Lines. I've been a member since the inception, although it's not active as I'd like to be these days.
Well, yeah, particularly since you do social media for a living.
Oh, well, I know. Is that terrible? It's like the carpenter whose house is falling apart, right? The plumber's pipes leak.
So Beavers Behind Enemy Lines, it's a Facebook group. It was started for Oregon Staters living in Lane County. We started with 3 people, I think 11 or 12 years ago, and it has grown on its own organically to over 3,000 people throughout Oregon, across the United States, and even around the world. Just the other day, someone posted from India. And it wasn't a spam post. It was a legitimate Oregon State Beaver fan who was commenting from India. So that's really cool. And we, of course,
all they have to do is type Beavers Behind Enemy Lines in the search bar on Facebook, and they can find it.
That should get you there. One thing that perhaps make Beavers Behind Enemy Lines, or BBEL, a little different than the others is this isn't a place for angry beavers. This isn't a place for calling out other fans. It isn't a place for dissing the team, for calling for people to get fired. And that's a little difficult sometimes when things aren't going well, but it really is for celebrating Oregon State and Oregon State student athletes. Now, although I did say we don't call for people to get fired, we might have to make an exception or two if it comes to certain Pac-12 commissioners. But other than that, it's a positive place.
Sounds great. I encourage everybody to go find it. There's always something good, fun to read about being a Beaver across the country, around the world, and just our overall love for the programs that make up Beaver athletics, and of course academics to celebrate.
Well, and it's everything Oregon State. The Oregon State University is doing some incredible things for students and incredible things in research. They truly are changing the world in many ways. And people like to talk about sports, but there is a lot more. And for those of us who actually live in Eugene, from time to time, there are some posts about what it is like living amongst the Ducks.
You mentioned that word. You just don't say that word.
Lowercase. That's
waterfowl,
not a capital.
Waterfowl.
That's not a capital D. That's a lowercase. Or I think in my writings on BBEL, I usually refer to them as the zeros.
I typically refer to them as whole.
Yeah, I've heard you do that.
Yes, that's my favorite. I've all the ones we've tried. Well, listen. So moving on. Little Birdie told me that you have access to the entire court filing from last week. Is that right?
Oh, and we check it every day for new filings. And so, what is filed and what hasn't been filed leads to some observations, and that's how we get this list of 9 things from the Pac-12 court file. Should we start with that?
Let's go.
You ready for number 1?
Always. George K. has picked sides.
And that seems to be really true. Maybe I should start off with the disclaimer. I am a practicing lawyer. I practice law behind enemy lines in Eugene, Oregon. I'm a business lawyer. I am not licensed to practice law in Washington. I have not been hired by anyone connected with this to render legal advice. I don't have any inside information, but I do have what I have been able to glean from the court file and from watching the oral argument. So the Pac-12 commissioner, I have problems with George's last name, so I've been calling him George Clinker. Now, calling people names is against the rules for Beavers Behind Enemy Lines. So yes, I understand I'm being hypocritical here, but maybe we could call that situational ethics. But in his filings and in his oral in the argument of his attorney, he claimed that he is put in a terrible place, put in between the two that are there and the 10 that are leaving. Well, that may be true. That could very well be true. But when you're the person in the middle, you don't take sides. You don't go to the court and make the argument for the people who aren't there. You say, I'm in a terrible position. Judge, tell me what I need to do, and I will do it. That's not what George did. George made a number of arguments in opposition to the motion for a TRO, and he was making the arguments for the 10 traders. Interesting enough, his very first argument, and typically in these things, you try to put your strongest argument first, is that Oregon State and Washington State did not have the necessary parties before the court. They didn't, they don't have the 10 departing schools. Now, there's reasons why Oregon State did not name them and Washington State did not name them. And Oregon State said, hey, if anyone, Oregon State's attorney said, if anyone wants to join this lawsuit, we will not object to it. And so they are free to intervene. And we're going to talk about that in a moment. But their number one argument was, hey, wait a minute, everyone else ought to be here. They aren't. But his attorney said something else near the end of his prepared comments. And he stated, I'm gonna read this verbatim. It is irresponsible that OSU and WSU put the conference and the commissioner in a terrible position. So evidently, this is all Oregon State and Washington State's fault. And if the commissioner, who should be saying, I'm stuck in the middle, tell me what to do and we will do it, is instead saying that this is Oregon State and Washington State's fault for not allowing people to divide up the spoils of the conference.
So they blame the rape victim.
So in my opinion, George has picked a side, and it is not with Oregon State, and it's not with Washington State.
Now, we talked this last week. He's the commissioner of the anything. He should be picking a side. He should be picking the side of Oregon State. We're the two remaining members of the conference represents the conference.
Well, you would kind of think so.
So point number two.
This is interesting. I looked up the law firms for the attorneys involved, and the OSU attorneys, Kieker, Van Nest, and Peters, and I believe the lawyers who are present are from their San Francisco office, but they have offices in other cities. But they have a very large, very active antitrust department. I think we talked about the other day is that I am certain that they have someone in their firm has antitrust experience. Well, they highlighted 10 partners in their firm for antitrust. And behind the 10, you have all kinds of support staff and associate attorneys. So they are well positioned. But here's something else. They list as their representative clients for their antitrust division the Major League Baseball Players Association as an antitrust client. So not only are they familiar with antitrust, but they're familiar with antitrust when it comes to sports. So this is very interesting. But you may ask, well, what about Washington State's attorneys? What's their experience? Well, they promote, and their firm is Wheel, Gottschall, and Manges. They promote their expertise on restructuring all kinds of organizations in all kinds of ways. And so we have the antitrust litigators who can hopefully help negotiate a resolution. And then we have the deal makers who know how to structure a new Pac-12. For people who think
that is very interesting. You got both sides covered.
For people who think that Oregon State has just been sitting around doing nothing, letting things happen to them, no. I think they were very thoughtful with their choice of counsel, and it will be very interesting to see where that leads. So we talked about George and how he picks sides, and people have asked me, well, are the 10, are they paying him money? Why is he taking this position against Oregon State and against Washington State? Well, here that's kind of interesting. During the TRO hearing, the reason for this meeting, to which Oregon State and Washington State objected, was in part to pass an employee retention agreement.
Okay.
And they talked in the hearing about how many employees have been contacted by others to try to recruit them. But the Pac-12 attorney, George's attorney, made an interesting statement. And this is one of two statements which I am surprised the attorney made, and possibly the attorney would like to have back. But at one point, he referred to the retention plan as a retention plan for the commissioner and other key employees. So if you're the 10 traders and you want to get money to your boy George because he's making your arguments for you, how do you do it? Well, we agree, the 10 of us, we agree to give him a huge bonus on his way out the door as part of a retention plan. Now, is that what the employee retention plan originally said? I don't know. I had hoped in the court filings that we would see that. I had hoped that we would see a couple of other things as well, but we did not. And so all we know about that is what the attorney said in court. But George's attorney let slip that George was a beneficiary of the retention plan, at least the retention plan that George was proposing to the members.
Right, and I read as well, whether I know it's true or not. It covered everybody but him. The one they voted on. The 12 schools unanimously on the plan, and I believe it was put by Oregon State and Washington State, and everybody agreed to it. Did not include anything about George Pay, now, future, anything.
Well, that's good. And that would be a good result, and I hope that's true. Me too.
The fact of the matter is you've now talked about it. Sides, and attorneys there are, so forth. It's very obvious, at least to this person, that there's collusion taking place between George and the treacherous 10, as you've called them, so that he does get his golden parachute. I brought that up last week before. That's what this is all about. He cares nothing about anything except getting his multi-million dollar golden parachute package.
And Tony's opinions are just that, are opinions. He has no inside information, at least as far as I know. No one has told him about actual collusion, but what he is saying is from the snippets of what we've seen, it leads to that conclusion. And
a little bit of common sense. I know there's not a lot of that out there anymore, but common sense. Otherwise, he'd be fighting like hell to help. Let me put it this way. If he wanted a future with the Pac-12 and whatever that constitutes after restructuring, etc., he would be fighting on behalf of Washington Oregon to show his loyalty to those who would be hoping to retain his position.
Well,
even though I don't think there's any way in hell they would keep him anyway after how bad it turned out. But if he really had any interest, he would be fighting to keep it multiple ways. And that just ain't it.
If this was an audition for a position in the new conference, I think he's blowing it.
Exactly. All right. Next on the agenda.
No scheduling order. What does that mean?
They haven't got their second meeting set, right?
Their second hearing. As we talked about before, a temporary restraining order is just to cover the gap in time before a more comprehensive evidentiary hearing where the court can be advised and make a decision on whether to issue an injunction from that point until the end of the case. And typically those happen in 2 to 3 weeks. I was thinking it would be 3 weeks from the hearing, which would be 2 weeks from yesterday. And the judge said, confer, get me a schedule for expedited discovery, for briefing, for oral argument, and we will get you on the court's calendar to satisfy your needs. So if you had a scheduling order to come for in the next 2 to 3 weeks, you would get that to the court right away. Now, if the parties can't agree, and this has happened on cases I've been involved with, each side then submits their own order, or says, "Well, we've tried talking to the other side; they're not being reasonable. This is what we think would be reasonable." And the other side would submit their own order and said, "It's not us, it's them." And the judge would intervene and said, "This is what we're going to do." We haven't seen any of that. What does that lead to? That leads to the suggestion, not that they're not talking, but that they are talking, but they are talking about a settlement. And we've talked about this a little bit before, but looked again this afternoon, and there is still no filings of any kind regarding anything to do with scheduling a preliminary injunction hearing. So I take this as a positive sign and confirmation that they probably really are talking about settlement. Because if they weren't, we would see this.
100%. 100%. I think you'd also see walking going on in various channels, social media, whatever, from both presidents, both ADs. They've been interestingly mum about things other than saying we're working on it. I find that interesting, and I also go back to our previous conversation where it was all about and other people are finally picking up on that. The magic word discovery.
Yep.
and people they don't want it. They don't want those comms at all.
Well, and there's two types of discovery. There is the discovery for the immediate preliminary injunction hearing, but then there is the discovery for the case as a whole. And people have asked me, well, if you're not a party to the lawsuit, can you still be compelled to turn over documents? And the answer is yes, and it's called a subpoena. You can subpoena the Big Ten, you can subpoena the Big 12, you can subpoena the ACC, you can subpoena Fox, you can subpoena ESPN. And those are something that you don't want to see. You might even be able to subpoena communications between other universities and those other conferences as it relates to the realignment issues.
100%.
In their respective TV contracts. So yeah, that's that second type of discovery that would be continuing on beyond the preliminary injunction hearing, and the expense for Oregon State would probably be over $1 million just for discovery, and a similar amount for Washington State, a similar amount for the conference, and then the cost imposed on others as well. Hey, let's get to a little bit about what is it that the opponents are doing. By the opponents, I mean we're talking about George, we're talking about the University of Oregon, we're talking about the University of Washington, and we're talking about the 8 other traders. And they seem to want it both ways. We want out, but while we're here, we still want stuff.
Of course.
Not only do we want stuff, but OSU attorney McMichael revealed that the departing schools wanted the conference to pay for their transition cost, transition from one conference to their new conference.
I'll give them credit. They've got Wavos the size of antelopes. I don't know, man.
And so how is it that they're doing this? Because, I mean, clearly they knew about Article 2, Section 3, which is what we talked about last time. They know that it's there. And everyone did something similar. But we'll take a look at the
letter.
We call it the Holes letter to the conference. This too was in the court file, and for people who want to read this on their own, I will post this as a file on the Beavers Behind Enemy Lines Facebook group.
Nice.
But second sentence: for the sake of clarity, the university is not delivering a notice of withdrawal at this time in contravention of Chapter 2, Section 3 of the conference bylaws. That's what they're saying. And then they say their last sentence, but we understand that the university will be excluded from conference discussions pertaining to matters occurring after August 1, 2024, such as media rights agreements and new conference member considerations. So
after
no,
2022.
After August 1, 2024, which is when the 2023-2024 academic year ends.
Gotcha.
So they're trying to have it both ways. Now, it's interesting. The Seattle Times did a little blurb on this, and their article was posted on Beavers Behind Enemy Lines by one of our good members up in Seattle. And the Seattle Times said, the University of Oregon and the University of Washington, who sent the same identical letter, acknowledges that they don't have a right to participate. Well, that's not what this letter says. And so some people, I think, were reading a little too much into this letter and reading a little too much in what the Seattle Times said. But what is it that University of Oregon wants? and University of Washington wants, probably everyone else, they want to stick it to, this is opinion, they want to stick it to Oregon State and Washington State just one more time.
Of course,
it's everybody's out for themselves, and we don't care if these two are left along the side of the road with absolutely nothing. We want to pull out as much as we can. And
they want to gut it, and they don't care.
They don't care.
And that's why they think official notice of withdrawal has to be something on letterhead submitted to the conference, like the letter you just showed. But the opposite is true in that at least if you haven't submitted a formal letter, but at the same time you've done announcements, posts, graphics. The new conference welcomes you with open arms. And I know that we talked a bit about that before. Does that not constitute notice?
When you're a lawyer, you take your facts as you get them, and you represent one side or you represent the other. But if you're not involved, you can say, I would much prefer to represent these guys instead of those guys. And I think that most honest lawyers, and maybe that's the wrong word, but I think most people who don't have a dog in the fight would say that Oregon State and Washington State have the much better argument. But that was part of the Pac-12's argument, is trying to separate. No. They're not withdrawing yet. They don't withdraw till the end of the year. It's not about the date of withdrawal. It's about the date of the notice. And so I think they lose out.
And what constitutes in their mind a notice.
But the question here was, what is it that the departing 10 want, and their representative George K. What do they want? Well, they want it all, and that seems pretty clear.
All right.
No
one seems to intervene.
So we talked a few moments ago about the Pac-12's number one argument against the motion for the TRO, and it's that the proper parties, the other schools, were not before the court. Oregon State said, if they want to be here, we welcome them. We will not object to their joining the proceeding. Well, guess what? In the 1 week and 1 day since that hearing, at least as of this afternoon, there has not been a single motion to intervene. Not a single motion.
For us laymen.
Which means
none of the schools have joined in the fight.
And one interpretation from that is they're not gearing up for battle. They are talking settlement. That's what I
absolutely.
That's why I think that this this conclusion is, or not conclusion, but this one point is important. If they were gearing up to take on Oregon State and WSU, they would be racing to the courthouse to do so. Oh, that reminds me. Someone shared on Beaver's Behind Enemy Lines, and I don't mean this as a commercial. It's just, if anyone else wants to take a look at it, this is where you can find it. But it was a video from Coach Leach, former WSU head football coach, about if there was a fight between the mascots, what mascot would win. I don't know if you've seen that video or not.
I've seen it a couple of times. It's vintage pirate. That's all there is to it.
Yeah, and so if folks were intervening, perhaps that video would have be some help in trying to determine who would win. But no one is intervening. But if you haven't seen the video, go find it.
Our next topic, OSU and WSU's fiduciary duty.
Yeah, I think this came up briefly when we talked a week ago. You've seen it reported that Oregon State and Washington State, if they're the only two votes on the board, then they could say that in order to be eligible for conference championship, you have to be a voting member of the conference. No, they can't do that. They don't want to do that. And they actually made some assurances to the Oregon State Attorney made some assurances to the court of not that they wouldn't do just that, but they would be fair. So notwithstanding Chapter 2, Section 3 of the bylaws, where it talks about notice of withdrawal, if there's a notice of withdrawal, you don't cease to be a member of the conference. You just cease to be a voting member on the board. Well, the voting members on the board have a fiduciary duty to all the other members, whether they vote or not, whether they have done Oregon State and WSU dirty or not.
Correct.
And if you look at the Pac-12 handbook, and the file for the Pac-12 handbook has been posted in the file sections of Beaver's Behind Enemy Lines for anyone who wants to find that. And it's long. There's a lot of pages, and it goes into a lot of detail, and it goes into specific sports, but it also goes into the allocation of the revenue earned during the calendar year, or rather the academic year. So Oregon State couldn't say, well, we have, according to the Pac-12 commissioner's attorney, there's going to be $500 million coming through the conference this year. Oregon State and WSU couldn't just say, well, that's a two-way split. That's easy math. No, you can't do that. So they have the fiduciary duty to treat the others fairly. They have a contractual duty to treat the others fairly. And they also have a duty to follow the specific provisions of the conference documents. So
now I would expect nothing less from Oregon State and Washington State, just from people and from your standpoint. We talked a bit about that. How much fun it would be, but at the same time, it makes no sense whatsoever. And again, folks need to understand, even though, and mentioned this a couple of times. This isn't about 23. It is about next year.
Yes.
The conference has to operate this year. There's rules in place this year. All the other 10 schools are still Pac-12 until next year. And so they're entitled to whatever the arrangements are, the current bylaws and things like that for this year. Where it gets interesting is like where there's future payments. Like 10 years or something like that, where tournament money, things like that continue to come in over time because credits earned by how far you go, that kind of stuff. And that's where it can be like, no, you're gone. After this year, you get nothing. We'll continue to receive that as a conference, and we will then decide how it's split. Whether it's just the two of them, or they add 6 more schools, and those people get a portion of whatever it is. However, that's what we're talking about here.
That's right. So those shares that will be dispersed to the conference during the current academic year need to be distributed evenly as set out. Now, where you may get some disagreements is there's the $50 million that's owed to Comcast for overcharge. I mean, that's a problem left, but not by George K., but by his predecessor.
Right.
There had been discussions that there was a $40 million emergency fund, and that debt would be paid for from the emergency fund. We don't know what resolutions had actually been adopted by the board, but assuming for a moment that maybe that was the plan that people were talking about, but no decision. If no decision had been made, it may be possible to say, no, let's pay that out of current revenue, which means it gets divided evenly. And let's leave the emergency fund because we think the conference is in emergency and we kind of need the money. An emergency created by you fools. So those all will be the issues that Washington State and Oregon State will have to thread carefully, and their attorneys will be involved, and the attorneys for everybody else is going to be involved. And boy, I wish I was one of those lawyers. But anyway, if I was one of those lawyers, I couldn't talk with you, Tony.
I hear you. Now, who has the most to lose in all of it?
Wow, what a great transition there, Tony. It's almost as if you've seen the list.
I can neither confirm nor deny that, Senator.
Yeah, we'll conduct some discovery. I think it's ESPN and Fox. They had this plan. It appears, it seems, it's my opinion, that they had this plan for dividing up college football, and they want kind of what they consider to be the elite of the elite, probably based upon the brands and the size and the money that is spent on these athletic programs. Speculation that when realignment is finished, it will be 2 conferences, and there'll be 20 to 35, and I don't know where 35 comes from, but 20 to 35 schools among these 2 conferences, and everybody else will be left on the wayside. And that Oregon State and Washington State University are just the first 2 of many that are going to get cooped. And
we've talked a little bit about that too. And I think it's further. There will be no conferences related to college football.
And
you're going to have a very European style relegation soccer kind of a thing. You're going to have your top group, then you're going to have another group, and there's going to be between top and bottom, and middle and top, like that. So that they can have their own play. They can have their own playoffs, and all that kind of stuff.
Well, soccer kind of started becoming a thing when I was in kind of late in grade school. I always thought soccer was a communist conspiracy. And you're not saying anything here to change my opinion on that.
No. And I'll take it further. You just look at some of the agreements these new agreements that they had at the Pac-12, ACC, much smaller degree, but about how they had additional money available for expansion up to a certain level. And I think with the Pac-12, Big 10, like 18 or something like that. So they were already factored in the pilfering of other conferences over the course of the 12 months or so, 24 months.
Yeah, and is any of this what's called a horizontal restraint of trade? And people are going to be looking at what could be discovered very carefully. And I think ESPN and Fox are vulnerable. And I'm not the only one who thinks that as well. But if you're, let's jump to the next one. But if you're going to settle and you want the real parties in interest, which was the Pac-12's argument against the TRO, didn't have the other schools there. Well, I don't think the real parties in interest are the other schools. I think the real parties in interest are Fox and ESPN.
100%.
And we'll see what's happening. So they're going to settle. I'm quite confident that they're going to settle. Now, it may blow apart at the end. I mean, you saw how hard it was with the media rights agreement between the then 9 remaining members of the conference, but they should settle. And as we talked about last time, I think that that ESPN and Fox will or could be part of it. But in terms of settlement, there's 2 different levels of settlement that could happen. And there's a little settlement and a big settlement. And the little settlement would be just resolution of the articles or the issues that are part of the current case, which is who controls the conference. And then if you have control of the conference, you have a couple of years to try to make things happen.
Agreed.
And what could that look at? So that'd be a little conference that gets us out of the Whitman County Court, and then we see what happens next. However, if you do a little settlement, discovery ends. You have to have a pending case in order for there to be discovery. You have to have a pending case in order to send out subpoenas to conferences and universities and to TV
unless you
networks.
file a separate lawsuit such as antitrust.
Unless you file a separate lawsuit. But I'd be a little cautious filing the antitrust lawsuit without knowing that I had everything lined out for the antitrust lawsuit. It would be a lot better if you're on a fishing expedition to fish with the pending case than to have a lawsuit which the other side would characterize as kind of a blind shot in the dark.
Agreed.
And that is why I am hopeful that as Oregon State Beaver fans, we like small ball when it comes to baseball. But I will tell you, for our conference lawsuits, I think we ought to prefer the big ball, the long ball. And that would be a settlement which brings Fox and ESPN into it because they have too much to lose. Now, why do I think this is going to happen in the next couple of weeks? Well, we've talked about it already. One, there is no scheduling proposals. And 2, no one has moved to intervene into this lawsuit.
Right.
And if you don't do a big settlement, you could have some problems going down the next steps. Now, maybe they have something totally else planned. I don't know. None of us knew that Oregon State and WSU were hiring antitrust lawyers with experience in sports antitrust issues and hiring lawyers that are experts in creative restructurings. I mean, on the lawyer's website, they say that most of the creative restructuring ideas in the last 50 years have came from them. Well, that's a pretty tall comment to make. And these are the people that are representing Oregon State. And so I have confidence in the lawyers selected. I have confidence in our athletic director. I have confidence in our university president. People who have met her are just struck by, are really taken by her. At the game on Saturday, a couple of people I know came up to me and said that they ran into her in the parking lot during the game and just how impressive she was. We've got good people working on this for us, and I am hoping that we're going to see a settlement in the next few weeks. And granted, everyone's going to second guess it and take pot shots and say they should have done this or they should have done that. Well, we weren't in the room. And I think with a very limited hand that they've been dealt, I think they've been playing it masterfully. And I look forward to seeing what they come up with.
I agree with you.
And
It's going to be fascinating.
I'll
say it again. This never, and I agree with you. This line of court. The settlement's coming. It'll be sooner rather than later. And I do believe that there's going to be some magic money that goes up out of nowhere for from ESPN, Fox, possibly CBS. Who else was involved in all this stuff? And we'll see. I think that will become the building block of the reconstitution.
So if you've enjoyed this video, if you would like to see future videos, subscribe. This is actually on my law firm channel. Yeah, but if you look at the other videos posted, there aren't a lot of them. We've done live streams during the pandemic, but not many of them were actually posted on the channel because they dealt with issues at that particular time. But if you want notice next time a video is posted, subscribe. The other thing I'm going to ask, though, is help get the word out. Share the link to this video on your social media. And Oregon State and WSU rightfully can't say very much. But hey, come talk to us. And if we don't know what's going on, well, we'll make guesses for you on what could be happening.
Educated us.
DeAndros years ago was speaking to a group for me, and he had his prepared comments, and then he asked for questions, and he goes, "Yes, ask questions, and if I don't know the answer, I promise you, I will make something up."
Well, on that note, everybody, thanks again for joining us. Huge game on Saturday. Go Beavs. And kick some Coug butt.
Hey, thanks, Tony Vegas.
See you, my man.